how we arrived at such point.
The story of Brown versus Board of Education, which ended legal segregation in public schools, is one of hope and courage. When the people agreed to be plaintiffs in the case, they never knew they would change history. The people who made up this story were ordinary people. They were teachers, secretaries, lawyers, ministers, and students who simplified wanted to be treated equally.
In 1954, large portions of the United States had racially segregated schools, made legal by Plessy Ferguson in 1896, which held that segregated public facilities were constitutional so long as the black and white facilities were equal to each other. However, by the mid-20th century, civil rights groups set up legal and political challenges to racial segregation. In the early 1950s, the NAACP lawyers brought class action lawsuits on behalf of black school children with their families in Kansas, South Carolina, Virginia, and Delaware, seeking court orders to compel school districts to let black students attend white public schools. Brown v. Board of Education in 1954 now acknowledged that one of the greatest Supreme Court decisions of the 20th century unanimously held that racial segregation of children in public schools violated the Equal Protection Clause of the 14th Amendment. Although the decision did not succeed in fully segregated public education in the United States, it put the constitutional on the side of racial equality and galvanized the national civil rights movement into full revolution.
One of these class actions, Brown versus Board of Education, was filed against the Topeka, Kansas school board by Representative Oliver Brown, parent of one of the children denied access to Topeka's white schools. Brown claimed that Topeka's racial segregation violated the Constitution's equal protection clause because the city's black and white schools are not equal to each other and never could be. The federal district court dismissed his claim, ruling that the segregated public schools were sustainability equal enough to be constitutional under the Plessy Doctrine. Brown appealed to the Supreme Court, which consolidated and then reviewed all the social segregation actions together. Erica Marshall, who would in 1967 be appointed the first black justice of the court, was chief counsel for the plaintiffs.
Thanks to the astute leadership of Chief Justice Earl Warren, the court spoke in a unanimous decision written by Warren himself. The decision held that racial segregation of children in public schools violated the Equal Protection Clause of the 14th Amendment, which states that no state shall make or enforce any law which shall deny to any person with jurisdiction the equal protection of the laws. The court noted that Congress, when drafting the 14th Amendment in the 1860s, did not expressly intend to require integration of public schools. On the other hand, the amendment did not prohibit integration. And in any case, the court asserted that the 14th Amendment guarantees equal education today. Public education in the 20th century said the court became an essential component of a citizen's public life, forming the basis of democratic citizenship, normal socialization, and forming the basis of democratic and professional training. In the context, any child denied a good education will be unlikely to succeed in life. Where a state, therefore, has a intention to provide universal education, such education becomes a right that must be for equality to both blacks and whites. Where the black and white schools substantially equal to each other, as the lower courts have found, after reviewing physiological studies showing black girls in segregated schools had low racial self-esteem, the court concluded that separating children on the basis of race creates dangerous inferiority and complexes that adversity affect black children early on. The court concluded that even if tangible facilities were even between the black and white schools, racial segregation in schools is inherently unequal and thus always unconstitutional. At least in the context of public schools, custody Ferguson was overruled. In the Brown 2 case, a decided year later, the court ordered the states to integrate their schools to recall the literacy.
This U.S. Supreme Court decision in Brown v. Board of Education 1954 is one of the most pivotal options ever rendered by that body. Some of our most noted scholars believe that the integration of school was the beginning of a brown spiral of education in the African American community. Dr. W.E.B. Du Bois explained in careful detail that he was making no special plea for segregated schools or mixed schools, but for education to this language.